At the Umansky Law Firm, we believe everyone deserves a second chance.
A recent question our firm had was, what happens when you get charged with possession of marijuana for the second time? My name is Lindsay Gergley and I'm an attorney at the Umansky Law Firm. When we're looking at how severe the second time is going to be, we look at a lot of different things. One of those things is what were the facts of the first case? Was the first case a misdemeanor marijuana case, meaning that it was an amount under 20 grams, or was it a felony level case where the amount was over 20 grams? Another thing we may look for is how long ago was the other case? Was it 10 years ago? Was it 5 years ago? Was it 5 months ago? Was it 2 months ago? The third thing we look is, what was the sentence on that first case? That if the prosecutor has access to whatever the sentence was on the first case, then they're going to ask for an increased sentence on the second case. So those three things are what we look to be able to counsel our clients at what they can expect. Now, when we're looking at a second type of charge, really any charge, when a person gets repeat offenses of the same type of charge, it's very possible the prosecutor is going to be looking at jail time. Not in every case is the prosecutor going to be looking at jail time, but we always prepare our clients that could at least initially be an offer that the state gives us. Another thing that we will look to that is very important in these type of cases is there any legal defenses? A lot of times, if there's a case that could cut either way, maybe in regards to the police doing something right or wrong, and the state might win or they might lose the entire case, the state may give us a deal. And usually those deals, which means something good or favorable for our client, if that happens, the state usually does that irrespective of all of those other factors that I've given you, because the state just wants to resolve the case. A lot of times people that when you get first drug cases that are not too severe or too egregious, the prosecutor will give you a chance to have what we call a withhold of adjudication. That means a withhold of the conviction and you're not actually convicted of the crime. Because you're not convicted, that causes you not to lose your driver's license. However, if you get charged a second time with a controlled substance offense, especially if you receive that withhold of adjudication that first time, you can almost guarantee that the state will be asking for an adjudication of guilt, meaning a conviction on the second marijuana charge. So while the penalties as far as probation or jail time, they may not be that significant, that driver's license suspension is very hefty, and that can be something that people with second marijuana charges really need to worry about, because prosecutors do look for that adjudication of guilt or that conviction on a second marijuana charge.